Hi, everybody. Welcome to our next session. I'm Mark Andreevich. I'm in the School of Media, Film and Journalism at Monash University and also a chief investigator with the ARC Center of Excellence for Automated Decision Making and Society. I'd like to start by acknowledging and paying respect to the traditional custodians of the unceded lands upon which we're meeting today. We acknowledge the Wurundjeri people and the Kulin clan as the traditional owners of the land on which the university stands. And I respectfully recognize elders both past and present and any Indigenous people who may be gathered with us today. As we consider how to build a better and more just society, may we honor and pay respect to the knowledge embedded forever within the Aboriginal custodianship of country. I'd also just like to say on a personal note, it's an honor and a pleasure to be here with you in this community of humanities scholars to celebrate and share the amazing work that's being done. And it's just really exciting and wonderful to see what's taking place. This panel will consider what is gained and lost from artificial intelligence with the allegedly revolutionary changes afoot and the associated digital technologies. With an special focus on the lens of Indigenous data sovereignty and issues of data access and ownership. I'll introduce each of the panelists as we go, and as you've become familiar, we've got questions in Slido. I'll keep track of that. And what we will do is, probably in the interest of time, because this is a somewhat shorter session, I think we'll save all of the questions for the end. So we'll do each speaker and then we'll reconvene for a question session. Our first speaker, Maggie Walter, is Professor Maggie Walter is Palawa, a member of the Tasmanian Briggs family and Distinguished Professor of Sociology, Emerita at the University of Tasmania. Her scholarship challenges standard explanations for Indigenous inequality with a focus on the subfields of Indigenous data, Indigenous methodologies, and Indigenous data sovereignty. In 2021, Maggie was appointed a commissioner with the Victorian Yoorrook Justice Commission, Australia's first truth-telling body, which is inquiring into systemic injustices from colonization to the present. She's the author of 6 books and over 100 peer-reviewed journal articles or chapters, and she will be speaking on AI and Indigenous data sovereignty. Please welcome Maggie Walter.
Naranini to Mark. Thank you very much. It's a bit scary to see how big my head is on that thing there, but I'm very pleased to be here today to speak about AI, Indigenous data sovereignty, and some of the risks and benefits to First Peoples for the growing part of AI in everyday lives. So I'm speaking today from the land of the Mukunina, none of whom survived colonisation, and in Lutruwita, Tasmania. So I also pay my respects to the people of the Wurundjeri Nation where this event is being held. So really, for better or for worse, AI is now part of the everyday lives of Aboriginal and Torres Strait Islander peoples. And while increasing efficiencies and development of beneficial technologies can produce positive outcomes, our marginalised social, cultural and political location suggests we will not share equally in these. So there are considerable risks also embedded in the ubiquity of AI, and these are also unevenly distributed. And they present significant challenges, emerging challenges for First Peoples relating mostly to bias, stigma and accountabilities. So my focus here is really probably turning, AI is a very big term, it covers a whole lot of things. So really my focus is around machine learning and the use of predictive analytics within social and cultural projects, because that's where we've identified one of the major risks. So there are others all over the place. So what we know is that algorithms are replacing human decision-making across rapidly expanding range of contexts, from everything, just from lending processes, consumer processes, interactions with all our societal institutions, public and private, and including services such as child protection and judicial sentencing. So our governments, we know, are already using predictive risk modelling in a wide variety of frontline services. Now, these are motivated in part by a desire to reduce costs through targeting those most at risk, and the language is something that we really do need to watch. So the people who are at risk of bad outcomes while meeting service delivery. So it's about supposedly service efficacy. But despite the growing call for transparency and accountability in machine learning and machine-driven decision-making, the logics underlying the assumptions are rarely available to the communities that they actually affect. So the appeal of predictive analytics can be partly attributed to the aura of objectivity around AI and the abstraction of algorithms from the people and the issues that their models describe. But, you know, the essential thing is algorithms operate as given inputs, and the learner algorithm and its functions are designed by human actors. They are still human sociocultural artifacts. So the data used in machine learning is also a social cultural artifact, and that is a product of very, very human and very particular human subjectivities. So whether algorithm designers or data generators, these technical experts are not neutral entities, and neither are the learnings they produce. The construction of algorithmic rules always involves choices and is fundamental. And it talks about choices about which assumptions are incorporated and which are not. There's always, you can't include everything, and sometimes those assumptions are mutually exclusive. So how those choices fall is fundamentally linked to the epistemic and the ontological realities of algorithm designers and data generators. In short, the algorithms reflect the creators, and it is their prioritization of knowledge holders and sources and their perspective of how the social and cultural world operates that actually decides what the algorithm will do. And in the vast majority of cases, those creators are not First Peoples. Now, you're all probably aware of the growing evidence, both here and overseas, of the racial biases in algorithms, and that can have very real negative impacts. And what they do is they unintentionally usually entrench rather than adjudicate existing inequalities. So there's a lot of evidence out of the United States that finds that sort of what are supposedly neutral algorithms actually end up targeting vulnerable groups. And I hate that word, but minorities and others. So what you have often is a set of assumptions underlying algorithmic construction that come from a particular worldview, and these are combined with place-based inequality. So as First Peoples in Australia, we are much more likely to live in poorer, heavily disadvantaged areas with relatively few services, making such biases almost guaranteed in predictive results. But this positioning, our positioning in society is not, it is not coincidental. It is directly related to our history as colonised and dispossessed Indigenous peoples of our lands and the ongoing intergenerational impacts of social, cultural and political marginalisation. The useful Indigenous demographic profile also makes sure that our young people are more likely to be targeted at risk, as being at risk. So in many respects, the profiling of Indigenous peoples is not new. It's been around since the start of colonisation. It is a tool of the colonising state. But what is new in the social policy arena are the opaque, complex and increasingly automated processes that shape targeting and profiling. So we as data subjects are included in a diverse range of data aggregations from self-identified political and social groupings to clusters of interest defined by data analysts and controllers. And often we are not aware that we have been of our assigned status and the implications of that. So it raises the important point that Indigenous identifiers need not be explicitly included in algorithms for Indigenous peoples to experience a disproportionate impact of algorithm-informed decision-making. So I know from one study that's come out of Aotearoa in New Zealand, although the Maori identifier was not included, because of the positioning of Maori youth within the population across all the socioeconomic indicators, they still ended up as a highly targeted group. So the complex relationship between structural inequalities, ethnicity, race, patterns of system contact, and system biases are still not well understood. And put add AI into this, and it becomes even more opaque and hidden. So, for example, in the child protection system, the Uruk Justice Commission, evidence before us, identified that First Peoples children in Victoria, their rise in the system with each level of interaction. So as a consequence, are much more likely to end up in care, despite the fact that the series of systems that in place are supposedly neutral and objective. So there are other signs of bias. So we also know in police predicting that First Peoples are more likely to come under control. So and this is one of the real areas of concern. So over the last 50, 100 years, the prejudicial outcomes of discriminatory policies have been unwound in Australia to some extent by Indigenous activism and also social justice movements, and within the academy as well. Humanities have been heavily involved in this. But with social problem identification decision-making now increasingly deferred to algorithms, the likelihood of Indigenous-linked injustice reworking its way back into the system rises exponentially. So if algorithm data rules target problems where Indigenous peoples are overrepresented, then the problematic indigeny will be the target. And unlike in earlier times, we cannot lobby, write letters, or protest outside of an algorithm. The hands-off myth of AI acts as justification for social intervention in justice. And that brings me to my final point, which is talking about data. So for First Peoples to actually benefit from AI, the data actually needs to be there to actually be incorporated and for use for algorithms and other parts of AI to actually create benefit. But data are not just free-floating phenomena. They have an underlying reality. They have tangible value as cultural, strategic, and economic resources that are only growing with the advent of AI and other big data technologies. So the big question I'm asking, and we're asking this all over the world, is who owns the data? Who owns that data? How should it be used? Who should have access to the data and under what circumstances? And who makes the decision about ownership? And what about the data that is not there? Just the other day, I had a really good conversation with a group in Canada of an Indigenous-owned data company. And they're very proactive in actually working with tribes in pulling data together that tells different stories of who First Peoples in Canada are, knowing that unless that data actually exists, those data exist, algorithms and other things and other parts of AI will not be able to use them. So all you will get will be AI constructed things using the data about us that are available, which predominantly fall on the 5D spectrum. They're about our disadvantage, they're about our difference, they're about our dysfunction, they're about our disparities, etc., etc. So it won't matter what the algorithm is, it will still come out as the problematic and deficit indigeny as the cause and the problem that needs to be fixed. So to finish, Indigenous data sovereignty and Indigenous data governance can play a big part in this, but of course it is not enough of its own. And I'm a founding member of the Mayam Nairi Wingara Indigenous Data Sovereignty Collective here in Australia, and a founding and executive member of the Global Indigenous Data Alliance. We are working with this idea around AI and what we can do, but it's not something that we can do on our own. We need to be really projecting the idea that AI is not neutral, and safeguards and other things need to be built in to make sure that it really just doesn't re-embed inequalities, or even further re-embed inequalities that we thought we had actually addressed. Welcome.
Thank you very much. As stated earlier, we will do questions after all of the speakers have concluded their presentations. Our next speaker, Leanne Wiseman, is a professor of law at Griffith University and an Australian Research Council Future Fellow. She is the founder and chair of the Australian Repair Network. She is an interdisciplinary scholar whose research at the intersection between IP law, data, new digital technologies, and the contracts that accompany them is addressing critical questions about the role that intellectual property plays in hindering or enabling access to new technologies. Her ARC Future Fellowship project, Unlocking Digital Innovation, Intellectual Property and the Right to Repair, is examining the emerging challenges that our software-embedded machines, devices, and equipment are creating for individuals and society. She'll be speaking on the topic, What Do We Really Own? The Data Erosion of Ownership. Please welcome Leanne.
I would also like to pay my respects to the Wurundjeri Nation, who are the traditional owners of the land upon which we meet today, and I would also like to pay my thanks to Julian and Jean for the invitation to address such a prestigious, esteemed audience. So, since the rise of embedded software in the many smart devices and machines that we now use and own, there has been an important but hidden shift in the relationship that we, as the machine owners and users, have with the manufacturers of those machines, and therefore the machines themselves. Intellectual property rights play a crucial role here. Today, I'd like to discuss how cars have become a key example of the ways in which IP rights, and more importantly, the contracts that accompany them, now control our capacity to repair, tinker, or modify those cars that we own. These undermine our very traditional notions of ownership. The classical ownership relation between humans and machines in this case has been transformed in complex and far-reaching ways. Before I start, I'd like to acknowledge also the excellent scholarship of MC Farrell, University of Virginia, who works in the space of smart cars and connected cars as well as many others. So let's talk about a connected car. I can give you a simple example. A 2017 Toyota Yaris that you can't hook anything up to is not a smart car. My 2015 Hyundai, I can connect to my phone, but I don't have Apple Maps. I don't have that connectivity level. But anyone who's bought a car in the last 3 to 5 years, you will have a very smart car. So what we mean when we talk about connected cars, a car is connected if it has internet access, which allows the car to share that internet access and data with other devices inside the car, and or with devices, networks and services outside the car, as well as with other cars, homes, offices, infrastructure and services. So a connected car can be connected in one of two ways. What we call tethered connectivity is where services are provided by devices that are brought in by the user. For example, you plug in your smartphone, or it might be a wireless dongle. These are becoming less and less common. What is more common is what we would call embedded connectivity connections. That's where the connectivity is built into the car using hardware, or what we call telematics control units, or TCUs. The TCU has an integrated modem that establishes connection between your car and the network. And what that means is your car essentially becomes a mobile phone. So you can see this is just a small indication of the type of conveniences and benefits that we've all become to know, whether it's warnings about traffic, changing lanes, safety aspects of the car, all of the bells and whistles, and those hazard lights that keep coming on and off as you drive around. What's really important, I'm building on the chipification of cars, as MC Farrell speaks about. Cars now have SIM cards. What this means is it really makes it like a mobile phone. As you drive around, your car will ping off the cell towers just as your mobile phone does. So it connects as it drives through cities and networks. What that means is the data from your car will connect with a mobile phone tower, but also with service providers that are also connecting. So you can imagine what we're looking at here. Your car basically is now a software-defined vehicle. It becomes a mobile phone, a wireless hotspot, a Wi-Fi receiver, and a Bluetooth receiver and transmitter. The cars record our habits, our routes, our schedules, where we live, where we go, how fast we drive, how many children we have, what financial information we use. This is all before you connect your phone. Once you connect your phone, and everyone loves to connect a phone, I took my car in for a service the other day. They give me a car for one day, and the first thing I did was connect my phone. You hire a car for a holiday, you'll connect your phone. Once you connect your phone, everything from your phone then goes through your car to your car manufacturer and to the network. So it may be your photos, your files, your images, your contacts, your messages. If you use Siri, all of your voice recordings will also be recorded, and the responses that you have, the telephone conversations that you have. So data is being collected by the truckload. I was trying to think of a cleverer word to say than that, but it's a truckload. So we know we love our smart cars. There are so many advantages and conveniences. In fact, last year it was 10 years since Bosch introduced the eCall. This is one of many examples of life-saving technology that's embedded in our cars, that if your car has a serious accident, that your car can call 000 so that emergency services can come to rescue you. So there are many conveniences that we love, that we rely upon in our cars. But when we think about the breadth, for example, of this Bosch eCall, this service is now available in over 50 countries and in more than 20 languages, and worldwide over 27 million cars from more than 15 car brands have this Bosch eCall installed in the vehicle. And obviously safety is a primary concern, we can't argue with that. But increasingly we are realising that there is a cost to all of this, these benefits and conveniences, and that is in relation to the amount of data that's being collected from us, from our phones and from our driving habits in the cars. So not only do our cars know what we weigh, but how much weight we gain. If you park your car at the airport and go on a holiday to the southern part of Italy and come back 3 weeks later, your car will know before you know how much weight you have put on. This is so that obviously the sensors in your vehicle can adjust the airbags, and that again is a safety reason. But do we really want our car to know how much that we weigh? So modern cars collect more than 25 gigabytes of data per hour. And this is much, much more than the performance and maintenance of that particular vehicle. As I mentioned, audio recordings, your voice assistant, if you use voice assistant in your car, We know if you have Alexa at home, the amount of false triggering that happens. Cars are noisy places. The more noise, the more astute the data collection will be around what you're saying, because it will amplify your voice above all of the outside noise. So this data collection and the fact that it's transmitted through cell towers and through other networks really reveals so much about our lives, our location data, where you've been. If you think your partner is having an affair, don't check their phone, check their car. That is, the biometric data is also being collected within the cars. So what we're seeing more importantly now is companies targeting AI, biometric analysis for inside your car to measure driver awareness, circumstances, and also Toyota debuts the emotional AI for cars as well. So all of these are being posed as a positive, that the cars are going to help us, save us. But again, what is really not being highlighted, and I think part of the reason I'd like to kind of highlight this today, is at the very heart of all of these new digital technologies, whether they're on platforms, chips, or through AI, comes with it the intellectual property rights. So what we see is Toyota here is interestingly pointing out, you know, you'll be able to get your car manual, which they don't really give you anymore in the glove box, through your car, but they're not telling you that you'll have to go back to Toyota to get that fault or repair done by Toyota, for example. So when we look at what role intellectual property plays, I'd like to pay tribute here to the Productivity Commission. The Productivity Commission in 2021 conducted a 12-month inquiry into what the barriers to repair were in Australia across a broad range of industries. Automotive industry was one of them. I've adapted this wonderful photo and figure that they produced and superimposed the tractor that they had here with a smart car. But these are the intellectual property rights that are in this vehicle. Obviously, the repair information, very important. How we as Australians, we don't make cars, we fix them. So to be able to pop the bonnet and fix your car is something that not only our motorists, but also our farmers have been used to for decades. Copyright, there's patents in certain technologies. Obviously, trademarks, we know the role of trademarks around the price of spare parts, hubcaps, etc. But what's really important, and what I'd like to focus on today, is this onboarding of the software into the cars, making them the smart car. This is a remit of copyright law. We heard a little bit about this yesterday from Kim. So it is the copyright in the software and the computer programs, and more importantly, the digital locks, the technological protection measures that are placed over those, that information, and the EULAs, what we like to call the end-use license agreements. It is only because they have the software protected by copyright that they can get us to agree to data licenses when we buy our cars. No one ever looks or knows about these contracts that we are entering into. They are unseen, unknown, but we are all agreeing when we turn our vehicles on to agree to certain amounts of data collection, restrictions on our ability to repair, going back to the authorised manufacturer for a whole range of services. And it is because of the contracts. Something I think that we really need to highlight about intellectual property, particularly copyright law, we can have all the defences in the world, and the Productivity Commission has recommended that we have a repair defence along with our fair dealing defences. Librarians here would know that all the fair dealing defences in the world won't help us when the contracts can override them. And this is what we're seeing. Contracts in library databases around access to knowledge, but contracts in our cars override any copyright defence. So, and the Attorney General's Department doesn't seem to understand yet that copyright is in vehicles and tractors and our toasters. They're still thinking journals and books, and this is a conversation that I'm having with them. So when we think about these IP, this is where it tips a balance between the owner of the vehicle and the manufacturer of the vehicle. Before, we used to drive the car off and it would be ours to own, to do with what we like. Now we drive the car away, we are beholden to the manufacturer because they are the ones who know when we get an error code on our dash, what that error code means. We don't have that ability. My local mechanic does not have the ability to do the repairs because they don't have access to the information that the authorised manufacturer has. These are the issues around repairability. The two big arguments that car manufacturers and most global manufacturers make against a right to repair are twofold. One is, we invest all this money in this technology and it is protected by our intellectual property. We cannot let you access any of our technologies for repair, modification, because that's our IP. And this is where I come in. I said, that's interesting. Talk to me more about the IP side of that. IP has always been about balance. It provides incentive and reward for creations, but it is also very much about public access and the public good. What we're seeing is an extension of IP into areas, into physical objects, in a way that we have not been seeing before. IP is the first reason. The other one is safety and security. We're protecting you from data hackers. All of this data, we're the ones who'll be able to protect you. So this idea of data vulnerability in motor vehicle is a huge one. We're seeing it all the time. It's even one that the UK kind of think that it's going to be an issue of national security. We know that car manufacturers can remotely shut down our vehicles at any point if they think that there is a hazard that may be life-threatening. And this is just one example of some of the literature that's going around. So think about the Australian motorist. This issue around car privacy and the truckloads of data that's being collected. The AAA, the Australian Automotive Aftermarket of Australia, is fully aware of this. They represent the $16 billion industry that we have in the Australian aftermarket. It's a significant industry for Australia. As I said, we don't make cars, but we fix them. We have workshops all over the country that have been denied access to the diagnostic software that they need from the global manufacturers. Most of the concerns from Australian drivers about data collection, who has that data. They're concerned about privacy for obviously very good reason. They're concerned about who that data is being shared with. They know that it's not just the car manufacturers, but it will be service providers. Just like your phone when you download apps. When you have apps in your car, every one of those app owners will have access to that information as well. So it is makes you more vulnerable in your car than your phone is, and people are concerned about the privacy on their phone. So what's really interesting is that when people talk about sharing their data, what they really want to do is share their data with their mechanic so they can get their car fixed. And maybe the government in some instances as well. They'd like to have their mechanics to have remote access to the information that they need. But they don't want the world to know their data. So 77% trust their local mechanics. 79% of people surveyed said that we need a legal framework around data. This data that's being collected is not protected by privacy law. It is not being encrypted at all. So they're really two big red flags. Where we sit in the world in terms of where our concern levels are, you can see here. So what have we done? Interestingly, intellectual property law is not going to solve the problem here. So what is really great for Australia, and this is really quite unique and we're world leading in this respect, is our ACCC, our competition authority, has been aware of this issue about the inability to repair our cars for over a decade. Since 2017, they've been looking at the fact that we can't get access to the information that we need, or the repairers can't. And in 2020, around the same time, the Productivity Commission was looking at the issues around repairability. The AAA called for a mandatory data sharing scheme so that global car manufacturers would be made to share the diagnostic data with independent mechanics. This is all about open and fair competition. Often the right to repair is seen as a waste, an environmental issue. It is that, but it is also about levelling playing fields between authorised repairers and unauthorised repairers. So what it really helped is we have a fantastic peak body, the AAA. This is Leslie Yates and Stuart Charity, who really pushed this and represented all of the thousands of mechanics in Australia. And we had a treasurer, Michael Sukkar, whose dad was a mechanic, and he got it. He understood what it meant. He went to a workshop and saw that to plug in a BMW car into a machine would cost sometimes between $40,000 and $60,000 to get access to the information from the manufacturer. So what Australia has, and this is unique, in our Australian consumer and competition law, which is a very weird place for it to sit, but we have the world's first mandatory data sharing scheme for automotive repair data in Australia. So no global car manufacturer can sell a car in Australia without providing access to the diagnostic software that we need to be able to keep those cars in operation and fix them. What is promising about this scheme is that the ACCC police it. They have a department of 7 staff, I believe. There are fines of up to $10 million for global car companies that refuse to participate and share their data. This is world leading and this is groundbreaking. And this is not to do, this scheme, put simply, overrides copyright in the software that the car manufacturers have to diagnose what is wrong with your vehicle. So this is overriding copyright. I can't stress that enough, because copyright won't recognise an exception for repair. So the competition law goes, great, we'll just say doesn't work for copyright. So the only IP that scheme will respect is patents, trademarks and designs, and not copyright. So it is fantastic to see. So what is really interesting is that around this time that the Productivity Commission was looking at the right to repair and this legislation was in draft form, the Federal Chamber of Automotive Industry that represents 28 car companies here in Australia said, well, data privacy, car privacy, we're onto it. We know what we need to do. When we looked at when those privacy policies looked at some of the global car manufacturers, they have really broad terms like, when you connect your car, our companies might disclose it to others for customer research, or use it to profile the people, or provide data to unspecified third parties for marketing strategies or data analysis or research and development purposes. So very broad, vague statements. So they've developed a voluntary code and said, we respect your privacy. We won't do anything with your data. This is soft. This is so soft. It's not mandatory. There's no enforceability. All it is really designed to comfort consumers without adding any privacy protections that the current law does not already provide. So it doesn't even require anyone to sign up to the code. So these are the areas of the relationship between manufacturers and owners This is that I think really shows the tension where we talk about the data relationship and who controls the data, this very issue that Maggie spoke about. Who owns the data that your car has generated? It's certainly not us as the owner of the vehicle, and that data is being shared. So what I'd just like to point out is this is not just an issue for motor vehicles. This is an issue that our farmers are struggling with fixing their tractors. We're dealing with agricultural machinery manufacturers at the moment. All consumer electronics, your Fitbits, phones, computers, kettles, toasters, fridges, washing machines, anything smart in your home, medical devices and assistive technologies. These are the very same issues around access to information that we need as owners that we're not currently getting. So thank you very much.
Thank you so much. Fascinating and horrifying in certain ways. Our next speaker is Dr. Jake Goldenfein. He's a law and technology scholar at Melbourne Law School and a chief investigator in the ARC Centre of Excellence for Automated Decision-Making in Society. His current work explores the ways law constructs the data economy, digital surveillance, including facial recognition, and tools for governing automated decision-making like a human in the loop and AI explanations. He'll be speaking to the title Lost in the Loop. Who is the human of the human in the loop? Where is he? Where is he?
Thanks, Mark. Thanks, everybody. Thanks, Julian and Jean, for inviting me, and thanks to the Academy for listening to me at this probably last presentation of the day. I want to acknowledge that where I live and work is on the unceded lands of the Wurundjeri people, and I want to acknowledge that my workplace, which is Melbourne Law School, has contributed to the forms of colonial expertise and colonial management that have been a big part of the ongoing process of Indigenous dispossession in Australia. So I'm here to talk about the relationship between humans and machines, as is thematic over the last couple of days. And I want to talk about this concept of the human in the loop, which has taken lots of different forms in the way law attends to automation. So in the face of automation and the changes that it brings to governance, production, social life, law has this reflex towards the human. By rehumanizing automation, by making human oversight a central feature of AI, the hope is that we can then safely materialize all of AI's promises. And the symbolic embodiment of this reflex, or this posture, I think, is something like the human in the loop, which is a concept that has been borrowed from engineering disciplines and transfused into legal thinking, but now ultimately has become a placeholder for a whole range of ways in which humans are threaded into automated technological systems. And in this talk, I want to try and unpack a little what the law is actually talking about when it talks about the human in the loop, because it's something that I think has become increasingly unclear and muddy and sort of compacted with numerous ideas. So the goal is to kind of break down and disambiguate the legal discourse on the human in the loop into sort of three separate domains of thinking. At the same time, I want to sort of expose certain dynamics that connect these domains of thought and show how these dynamics produce their own account of what the human is in the human in the loop. So the first dynamic, before looking at these domains, the first dynamic to pay attention to is the back and forth between the technical and the political. As we'll see, law is often trying to posit some sort of human with specific technical capacities. This typically then ends up colliding with reality in ways that show the limits of that specification. A second dynamic is the relationship between law and other disciplines, particularly the engineering discipline of human factors, but also human-centered design. You may not know very much about human factors engineering, but this is really the post-World War II discipline that explores how to properly integrate humans into control systems. In Europe, it was called ergonomics. But it's now absolutely central to understanding complex systems and how humans interact with them. And the third dynamic is this relationship between the human as a set of capacities and the human as a type of commodity object. And in these three, in the three domains of thought about human in the loop that I'm going to talk about, we'll see this slow shift from a conceptualization of a human that is apart from and then integrated with and then a sort of feature of an automated system in ways that exemplify this shift to the commodity specification of the human. And we see, in each regime, we see a sort of changing legal goal or telos, starting with accountability, moving to liability, and then finally safety. Now, all these dynamics are linked, all these regimes of thought are linked, and they sort of progress through this cycle of we have automation, we have anxiety about automation, we move to the human to address that anxiety, and this fails, and then it all happens again. So the starting point is something like the law used to work great until automation broke it, right? Law itself was not immune to the drive to automate everything after the Second World War. The emergence of computation invigorated a new type of legal formalism that saw the law, and especially administrative law, as capable of being broken down into flow charts and decision trees. One of the more notorious examples of this is the development of an AI expert system for evaluating citizenship status in the UK, a seemingly simple legal calculus premised on questions that appear to require little discretion in answering. Now, this approach is now replete across governments and government systems and government apparatuses around the world. Sometimes we hear about it in the sort of more extreme positivist fantasy of the idea of law as code. But really what we have is all sorts of automated decision-making systems throughout government determining or participating in the determination of rights and eligibilities. And often it takes the much more mundane form of what we call robotic process automation or business process automation, whereby statutory requirements are translated into structured software systems that guide decision makers along the decision process. In whatever form, this has always generated profound anxiety for legal theorists and public lawyers concerned with the exercise of public power. This way of making a decision means less room for the discretion necessary to accommodate the complex realities that these laws mediate, a privileging of technocracy over clinical expertise, a challenge to rule of law values like transparency, equality, and fairness, and a new form of humiliation for a human whose life chances are now the product of a mindless technical system. So how do we fix this, right? Enter the human in the loop. Here, in the first instance, configured in service of the goal of accountability. So we situate a human as the final decision maker in an administrative decision process, or at least available, or at least we situate a human as available to review automated outcomes. And in this form, we get things like the General Data Protection Regulations, Article 22, which affords a right to human review. We get jurisprudence like the recent Australian Pintarich and Commissioner of Taxation case that stipulates that administrative decisions require some form of human cognition to be decisions at all. We get Australian politicians outlining what they call the golden rule, this idea that only humans will take away our entitlements, never a machine. And we get, very recently, the New South Wales Ombudsman saying there's no such thing as responsible AI because only humans can be responsible. In this configuration, the human is posited as some sort of enlightenment moral agent, right? In the words of my colleague Connell Parsley, it's technology's non-technological other, a fully self-determining, infinitely capable agent operating as the cornerstone of liberal political legitimacy. So how does this go wrong? Well, it doesn't really work empirically. So for instance, scholars like Ben Green have demonstrated that it fails to improve decisions against clinical baselines in a whole range of domains. In fact, there's very little scientific empirical evidence that a configuration of a human in the loop like this improves decisions at all. But perhaps more importantly, it stylizes how automated decisions happen in ways that don't really accord with reality. So Ruben Binns and Michael Veal, for instance, have shown that this idea of a final human decision maker is just incoherent account of how automated decisions actually happen. So they produced a typology of different automated decision processes that demonstrate that how the human is situated at different places within an automated system for different purposes at different times. And the problem with stylizing automated decisions in this way is that all the things that happen before the final decision, like the risk scoring, the risk ranking, the accumulation of demerit points for not attending enough job interviews, all of that escapes it remains uncontestable. It remains subterranean to the actual decision, which is the fundamental product of a human mind. This framing means that abusive political programs like robo-debt can be narrativized as being caused by the lack of individual agency at the decision-making stage, rather than as a problem of systemic criminality and toxic political culture, which had to be surfaced through a royal commission. And now we've come to realize that we have a new anxiety around the situating of a human in the loop in this way. Our moral superhuman agent may not be as self-determining as our law demands, and in fact starts looking more like this, a kind of rubber stamp for an automated process. So what is the legal reflex then? Well, we say, the problem is our law isn't human-centric enough. We need to put the human at the center of the system rather than just at the end. And indeed, making human-centric systems requires acknowledging human limitations and how human capacities and rationality is bounded by its environment. So here we get a sort of second domain of legal thinking around the human in the loop. The question of who did what. This is law's kind of first dalliance with these human-factored engineering and human-centered design. And we get scholars like Ben Wagner saying that for a human in the loop to work as a governance paradigm for automated systems, we need these organizational measures. We need to ensure there's adequate support for them, adequate time and adequate information for individuals to perform their oversight task. We have Marion Oswald saying that we need to ensure humans can exercise their sort of secret procedural and tacit knowledges of factors that haven't been formalized and included in automated assessments. Ultimately, these are calls for recognition that there is some kind of hybrid agency at work in these systems. And the way to navigate this hybrid agency requires something like it's sometimes called a mabber approach, right? Humans are best at, machines are best at. And this is a paradigm of thought that emerged in these engineering disciplines in the middle of the 20th century. This is what was called the Fitts list, one of the first sort of systematic efforts to quantify what it is that humans do better than machines and what it is that machines do better than humans. I mean, in the 50s, it was mabber because it was men are best at, machines are best at, rather than humans. So embedded in this differentiation is the idea that humans have certain abilities and skills and machines have certain capacities, and these can be systematically leveraged for optimum outcomes. But this sensible recognition of human limitation produces something slightly more radical as well. And this is a reframing of the human oversight question in the terms used to describe industrial control systems, right? This means that the human in the loop is no longer about the human as a final locus of accountability or arbiter of rights. It's about integrated hybrid systems and the appropriate division of responsibility between human and computational components. Whereas human in the loop as a framework for humans began as a framework for humans taming egregious automation, in this conception, it becomes a framework for managing the awkward distributions of agency, responsibility, and liability in automated systems. The human posited in this paradigm is much more nuanced than law's Enlightenment liberal moral agent. It incorporates limitations and specific capacities. It is increasingly understood as, behaviorally as behavioral and having sort of bounded rationality. But it turns out that this more nuanced and limited account of the human still has problems. In the end, it turns out that humans resist being quantified into an abstract set of capacities that can be distributed into a who does what allocation against a machine. The technical specification approach always collides with the qualitative effects of automation, the ways in which automation always transforms human practice. This is a problem that human factors has long understood empirically, but the law sort of selectively ignores. And we get, from the 80s and earlier, this kind of ironies literature. Very famous article by Leanne Bainbridge, where she talks about how the human actually becomes worse and worse at their job as more of the tasks are distributed to an automated system. The irony is that you think you're making it easier on the human, but actually monitoring what they used to do is much more difficult. So the introduction of automation in ways intended to overcome human limitations, in the end, expands those limits in many ways. So that's the empirical problem, and the literature on industrial accidents speaks very much to that. But then there's also the political and economic undoing of these distributions of agency and responsibility. Charles Perrow, probably most famous for his book Normal Accident, reminds us in this classic article that human factors is itself a deeply political paradigm operating within the context of organizational prerogatives. And despite law's efforts to technicize the human in a particular way, the political realities of organizations and the industries they're operating in typically work to re-responsibilize the human despite whatever their actual level of control in a system. Once again, we have an industrial and organizational prerogative mimicking the New South Wales Ombudsman and saying, no, only the human can be responsible. But why? So one rationale as to why is that unless governments and AI industries can point to some sort of egregious human error, we as a society might conclude that engineering safe automated systems isn't possible at all. We see a similar and related, a related and updated version of this claim in the work of Madeleine Lish, formerly at Data and Society and now at Google, where she talks about humans are sometimes configured as a type of moral crumple zone, right? A sacrificial human designed to absorb the liability when something terrible happens, despite their inability to exert meaningful control. And this sort of emulsion of formal specification of human capacity, technological reality, organizational pressure and market force, I think, means we actually get very strange outcomes when it comes time to identify who is responsible. So I'm going to push back a little bit against this. So for instance, we recently had the outcome in the case of Rafaela Vasquez, who was the backup driver when an automated Uber vehicle killed a woman pushing a bicycle across the street. Vasquez pleads guilty to reckless endangerment for the accident. There's no prosecution of Uber because our theories of corporate culpability are insufficiently advanced to attach to Uber here. So it looks like we have something like a moral crumple zone situation. But in reality, it's a little bit more complex and unsettled because the guilty plea means that the actual disentanglement of responsibility was never analyzed by a court. There was no testing of how the organizational prerogatives, like removing the second safety driver that had previously accompanied these trips, contributed to the accident. There was no evaluation of whether the Uber's constant communication through Rafaela Vasquez through Slack on a device while she was in the car contributed to the accident. And And there was no analysis of the evidence that we get increasingly from the engineering disciplines working on this question of vehicle-human handoff, the points at which the vehicle says to the human, hey, I don't know what's going on, you need to take control, the evidence of which increasingly suggests this might not be possible to do safely at all. And here is our new anxiety, right? That in many cases, it is extremely difficult to define control systems that distribute responsibility in a sensible way, and that it might not be possible to do at all. And we see this in certain literatures, like for instance in Mark's work, where he makes the argument that humans are incapable of intervening in the sort of cascading flows of automation that they often encounter. We see it in the work of Louisa Moore when she talks about the sort of different epistemic registers of automated systems and humans making intervention impossible. So what do we do? What's the response? Well, the response is another regulatory formation. We acknowledge some sort of high-level commitment to human-centeredness. We acknowledge basic organizational requirements at the level of regulation, but we now need a way to incorporate specific context. So how does the law do this? Well, it asks the market to do it for it. We ask the market to technically specify the capacities, roles, and shape of the human. We let the market define human oversight according to its need for specific products. I need 3 or 4 or 5 more minutes. No, just a couple. So an exemplar of this, the EU AI Act, right? This is the regulatory requirement for human oversight that attends high-risk systems in this draft regulation. Many of the requirements are common sense, but quite vague. Design a system capable of being effectively overseen, whatever effectively means there. Build this capacity into the product itself, or give indications to the user as how to best perform oversight. But really, when you look at it, what the human is and what they need to do is deeply unspecified here. But that's intentional. On one hand, it's very hard to do in a regulatory instrument. And on the other, these rules are intended to be guidelines for designing human oversight as a matter of product safety, which acquires its specificity through a process of technical standardization. So in the EU, this involves a request for the drafting of a technical standard. In this case, it's the drafting of a technical standard for an AI system that is safely overseen by a human as a kind of disentangled commodity that can circulate in a harmonized market. I'll skip a bit because of time, but what I want to say here is that in this context, human oversight as a standard, as defined through a standardization process, becomes the product of a multi-stakeholder experience dominated by industry experts who work to specify human capacities in line with what fits their already in-market products. So for instance, for Microsoft Copilot, you get a product description, and then you also have Microsoft produce a standard that are created in order to define the human in a way that makes this product work. Similarly, you have Amazon selling human oversight as a software service. Like Microsoft, Amazon controls the infrastructure that other software developers use. But they also control a massive pool of gig workers doing Amazon bells, and this becomes a sensible way to build human oversight into a system in a way that takes advantage of your already dominant infrastructural control over workers and to satisfy your legal safety obligations. So here, the human is not so much a self-determining moral agent or a set of quantified capacities, but this versatile safety construct sufficiently malleable to fit into and optimize automated workflows. The human in the safety paradigm thus becomes a kind of legal technology to enable stable economies to form around automation. Now, to leave you, I give my prognostication about where this is going next, even though all of these things are still manifesting on their own. And this is, of course, very connected to the domain we've just seen and all the others, but I think represents something new. As the role of AI, particularly generative systems, transforms the processes of information and cultural production, I think we see the human now taking on a new role, not as a liability sponge, described by Perot or Elish, but as precisely the opposite, as a kind of rights sponge, right? As an entity that, by virtue of being human, is capable of attracting certain rights, like the right to go to market or property rights. And we see this prefigured, for instance, in the US Writers Guild agreement with the studios that show us how generative AI will continue to be used in its fullest capacity in the production of cultural goods, but a role for humans will always be retained in order that they can exercise precisely as much creative input as necessary to garner copyright protection. So it's human as minimum modicum of creative output. And I think this might be a sort of design for how the human is configured in AI systems moving forward. Thanks.